it seemed like it would be a great moment in front of a jury for the defense, but it ended up not being so great. At least that's what I thought. What did you think?
I love Blackwell in this case, from his opening statement to his cross-examination of Dr. Fowler. I think he's been the most effective witness, even though he is a civil attorney and he's here just as a special attorney general in this case. His cross-examination was very effective. Dr. Fowler was the best witness for the defense so far, but I think Blackwell scored some major points, both in terms of the white substance, which is clear that he was suggesting that it was chewing gum, but also the statement that he elicited from Dr. Fowler that even if George Floyd was suffering from heart disease or cardiac arrest, it was incumbent upon Derek Chauvin to render aid. And he really touched upon those last minutes, the last 4 or 5 minutes particularly. And I thought that was highly, highly effective, outstanding cross-examination by Blackwell.
Neama, what are your thoughts? You're sitting there as the prosecutor, and you've got the defense forensic pathologist saying undetermined. How do you handle that?
It's tough to handle. I mean, his credentials speak for themselves. He's been doing this for 30 years, chief medical examiner for Maryland. I know he's had some issues there and being sued, but I mean, this is exactly what the defense wants. They're not going to get an acquittal here. They want 1 or 2 holdouts. And Dr. Fowler said, I'm not here to confuse the jury, but that's exactly what he did. I mean, this is the first time we've heard about the carbon monoxide. We knew the tumor was coming because Nelson mentioned it in an opening statement, but he brought everything, the drugs, the heart, the arteries, and now we're talking about carbon monoxide, which hadn't even been previewed for any of us until today. So I thought he did a good job, and the defense, they're going to want to confuse just 1 or 2 jurors. That's going to be a win.
Do you see that, Neama, as well? As a former federal prosecutor, do you see consciously taking a chance of causing death or great bodily harm?
Absolutely, Vinnie. I agree with Dave here. There's no question this is culpable negligence, and that's really gross negligence in other states. This is highly negligent. Absolutely, second-degree manslaughter is appropriate, and as we know, this has happened twice before, and those officers were also charged in manslaughter in those cases. So this is a charge that I expected. Obviously, it's a 10-year max. She's probably going to serve 4 or less and get out, but that's the appropriate charge.
You've got her convicted already, Neama. You've got her.
I do. I've seen the video, Vinnie. There's nothing else I need to see. It's like George Floyd. The video speaks for
Neama, what should the officer have done? She should not have used a taser in that situation? Is that going to be the argument that prosecutors make here in court on this case? So what's the alternative if she can't use a taser?
Well, that was Dave's argument. I wouldn't necessarily go that far and say that she shouldn't tase him under this circumstance. But again, the consciousness just applies to the action itself, that she consciously pulled the taser and she used the taser. There's no intent required. This isn't second-degree murder, third-degree murder.
But you have to consciously take a chance. You're consciously taking a chance. That almost sounds a little bit like intent the way they write it here.
But it's not. It's manslaughter. As attorneys, we know it's manslaughter, and it's just a negligence standard and slightly more than negligence, that culpable negligence. That's what applies here. No one's saying that she should be prosecuted for second or third-degree murder like Derek Chauvin, but unquestionably, she took a chance. She was highly reckless. She pulled out a taser. She discharged it, and it turned out to be a firearm. What's more reckless than that? And ultimately, an innocent man died.
We all agree that the recklessness of grabbing the wrong weapon is. Let's bring back in our think tank, an important witness for the defense. But did they have the better day? Was it prosecution or defense? We'll start with Neama Rahmani.
Defense had the better day today, Vinnie, and I think I'm bad luck every time I'm on court TV. Last time it was Dr. Baker, and now it's Dr. Fowler. These are the only 2 days that the defense has won. Fortunately, next time I'm on, it's going to be after closing argument. But the reason Dr. Baker was so effective is he tied his testimony, and he created confusion. Obviously, we know that's what good defense experts do. They muddy the waters. But he tied his testimony to 2 real key pieces of evidence. And the first was the 2019 arrest of George Floyd. We know how important that was because the defense led with it, just like the prosecution led with the 911 operator and the police calling the police on the police. But the other thing that Dr. Fowler did is he tied his testimony into Dr. Baker. And Baker was a witness that I didn't like for the stake. They had to bring him on. He was the medical examiner. They sandwiched him in between better witnesses, but he really tied his testimony to Baker. That's why I thought he was effective. I think he may be able to get 1 or 2 jurors to hang. The only reason I'm hedging a little, and I'm not hedging, is the evidence that didn't come in today. I thought it was a big win for the prosecution. What we expected, Maurice Hall is not going to testify. That's the ruling that we thought Judge Cahill was going to hand down, and he did. I thought that was a win for the prosecution. But overall, because of how powerful Fowler was today, I think it was a win for the
tonight.
defense.
It's an aversion, so he doesn't have to make eye contact with the jury. And, you know, that's the other thing with this COVID-modified situation, Neama. They really can't see him at all. I mean, he's got the mask on, so maybe you could see his eyes, but if his eyes are down writing, you're not seeing his face at all.
Vinnie, I mean, I agree with Teresa. Criminal defendants, in my experience, they want to participate. Usually their defense attorneys are saying, hey, you know, especially you have a law enforcement officer here.
You know what they were writing in your trials? They're writing, I hate this smug prosecutor. He's so good looking and he thinks he's so smart. And no, I'm only kidding.
No, Vinnie, but in my trials in federal court, your case agent can actually sit next to you. So oftentimes out of FBI or DEA, believe it or not, they could sit there in court. You can have a law enforcement officer. Half of those guys or girls are attorneys, so they would give me amazing notes, either on the facts or the law. But here, I think Chauvin is preparing his appellate brief because he knows he's going to get convicted. So he's just identifying all those potential frivolous issues that he's going to raise on appeal.
Yeah, I mean, it's a high-stress situation. I'm not minimizing that. I appreciate you guys because we don't have that many prosecutors who come on, and you give us that great insight. Thanks so much. Please come back soon.